Hello, with us is one of today's giants of the legal profession, Edwin Smith. Ed is a partner with the Morgan Lewis law firm of New York and Boston. Ed serves on the Uniform Law Commission as a commissioner from Massachusetts. Most recently and notably, Ed served as chair of the drafting committee for the Uniform Law Commission's 2022 amendments to the Uniform Commercial Code. Welcome, Ed.
Well, thank you very much, Don. It's very strange to be called a giant when I'm only about 5'5", but I appreciate it. It's aspirational.
Giants come in all sizes. So let's just jump in here. Could you discuss generally the 2022 amendments to the Uniform Commercial Code and what they are all about?
Well, I'll give everyone a little bit of history here. The Uniform Commercial Code, as most of you know, is a matter of state law. It is the sponsors of the Uniform Commercial Code are the American Law Institute and the Uniform Law Commission. The code was originally drafted in the 40s and 50s when we had a goods-based economy. It was revised a few decades later when we had more of a service-based economy. And now we're just trying to deal with the fact that we have a digital-based economy, or at least part of it. And when you look at the Uniform Commercial Code, it doesn't quite address that. When you look to Article 2 and Article 2A, that deals with the sale and lease of goods. If you look to Article 3, it deals with negotiable instruments that need to be in some sort of writing. We do have Article 4 that deals with payment systems, and Article 4A that deals with fund transfers, and Article 5 that deal with letters of credit. And for the most part, they can adapt fairly well, but we start to struggle a little bit when we get up into the upper articles of the UCC, Articles 7, 8, and 9. So that's where we decided that we needed to focus to see whether the Uniform Commercial Code needed to be modified in some way to account for changes in the economy. And Don, you probably know this, that there was some real market pressure here. For one thing, if you look to virtual currency and how virtual currency works under the existing Uniform Commercial Code, generally you could have virtual currency that's held with an exchange or custodian, and the parties could opt into Article 8 of the UCC and treat the virtual currency as investment property, as financial assets. And you have fairly clear rules in that case as to how you take a security interest, what the adverse claim cutoff rules are. It works pretty well, but not everybody wants to do that. Some exchanges don't want to do it. Some customers don't want to do it. They want to hold their virtual currency directly. And then when you look to see what virtual currency is under the UCC, it's a general intangible. There are no adverse claim cutoff rules. Even though people treat virtual currency like money, it's really not money. If someone steals my virtual currency and I exchange it with you, Don, for goods or services, you don't get any title from the thief. I can come after you and say that's my virtual currency. Whether that happens is a practical matter or not, but people get concerned about it. And then when you're talking about taking a security interest, oh my gosh. If you're not going to flip into Article 8 and play by the investment property rules, you have some real quandaries, because as a general intangible, that virtual currency, you can perfect a security interest in the virtual currency only by filing a financing statement. And yeah, it's pretty easy to file a financing statement, but then you've got to figure out whether you're first in priority, because you're subject to the first or file or perfect priority rule. And if someone else has filed first covering the same sort of collateral, which could be described just as general intangibles rather than virtual currency, they're in a first position. And if you want to be in a first position, even though you filed a financing statement, you've got to go get a subordination or release from that party. And then if the debtor is an individual who might move to another state, you got to monitor the debtor, because if the debtor moves to another state, there's a 4-month period to refile in that new state to maintain the perfection of your security interest. So that's really a pain for secured lenders. Now, it gets even worse with Bitcoin. With Bitcoin, it gets even worse because with Bitcoin, the definition of money under the UCC includes any medium of exchange adopted by a government. So Bitcoin arguably is a medium of exchange, and it was adopted by El Salvador and the Central African Republic. So that meant that under the UCC, there is an incredibly credible argument, a big credible argument, that Bitcoin is now money. Now, why does that make a difference? Well, if it's money, it's no longer a general intangible. It's money. And the only way you can perfect a security interest in money under the UCC is by possession. Well, that's a cruel hoax, because you can't possess an intangible. When we talk about possession, we're talking about tangible objects, not something that is intangible like Bitcoin. So the only way you can perfect really is Bitcoin is by going through the Article 8 route, which may be difficult to find an exchange that does what you want it to do. It may not be, but you're going to have to go through all of that pain. So that's one area where the market was coming at us and saying, you got to do something. And Wyoming did. A few years ago, Wyoming started to come up with its own statute, and which really spilled over into the Uniform Commercial Code. So other states were starting to replicate what was going on in Wyoming, and we can see the uniformity of the Uniform Commercial Code sort of disintegrating before us if we didn't act. The other area where there was some real market pressure was in trade finance. During the pandemic, we really saw a lot of parties wanting to issue bills of exchange and promissory notes in electronic form. And in the United States and in most other countries, you need to, the promissory note or bill of exchange to fall within the rules for those sort of instruments need to be in writing. And so no one quite knew what the rules were for bills of exchange and promissory notes in electronic form. You do have in the United States the Uniform Electronic Transactions Act, and you have ESID and this concept of a so-called transferable record. But there was no confidence, even if you opted into those provisions, that transferable record would be recognized in other countries as well. So there was a lot of desire in the US to try to address electronic bills of exchange and promissory notes. And so that's really how we got there, Don.
Well, cool. And wow is all I can say to that. But so what was the driving force behind the 2022 amendments?
Well, I think the driving force really came from those market pressures and from what Wyoming was doing and what other states were starting to do on their own. So the Permanent Editorial Board for the Uniform Commercial Code looked at all of this and made a recommendation to the sponsors, the American Law Institute, the American and the Uniform Law Commission, that it was time to look at the UCC, not just from those two areas, not just for virtual currency, not just for trade finance, but to look at the entire Uniform Commercial Code and to determine whether there were provisions there that need to be adjusted. for technological developments in general.
Okay. So what was the process for developing and drafting the 2022 amendments? You're the expert on this since you chaired that process.
I did, and it was a great honor to do that. There was just an amazing team of people who worked on these amendments. We started off with the American Law Institute, the Uniform Law Commission, appointing a study committee that flipped very quickly into a drafting committee. The members of the committee were comprised of uniform law commissioners and members of the American Law Institute. We had advisors from the American Bar Association. I had a vice chair, Juliet Orangello, from Pennsylvania, uniform law commissioner. We started off with a terrific reporter, Stephen Harris, from Chicago Kent Law School, who unfortunately passed away into the first year of the project. And then Professor Charles Mooney at University of Pennsylvania Law School jumped in and really picked up the baton to keep going, and just did a fantastic job. And I also had a vice chair, Steve Sepidek, who at the time was at Gonzaga and now is, I think, an adjunct at Vanderbilt. But they were terrific. And then we had just a whole number of observers. We had, I think, last time I counted, we had 350 observers. And anybody who wanted to participate in this process could. I mean, these were all open meetings. And even though the first two meetings were in person, the pandemic hit. So then the next 13 meetings were all virtual. And we would have maybe up to 100 people at any one time attending these meetings. And they were, I often refer to this as having a meeting with the cast of Ben-Hur. So, you know, how to run a meeting like that, where we could talk about broad policy type comments, but eventually we had to break up into smaller groups. And the group that worked on digital assets, if you can believe this, met every week for 1 hour for 10 months to come up with the provisions that deal with digital assets. And this small group consisted of a bunch of us who were UCC geeks and a bunch who really knew the technology. And so we were often started off talking different languages. And eventually we got to some common ground. And this group was also, those who understood the technology were also very plugged into those in the crypto community and elsewhere. So we got a lot of great feedback. Now, once again, we looked at the entire UCC, not just those in the particular areas that I mentioned. And we also had a lot of participants from international law reform groups and lawyers in foreign countries who were looking at these issues in their own countries. And so we got a lot of great feedback. I've got to say the work of this committee was just tremendous. So we received approval in May from the American Law Institute and in July from the Uniform Law Commission. And now we expect these amendments to be introduced in state legislatures, probably starting in 2023. So this was a 3-year project with a lot of input.
Wow, that is fascinating, and I'm wondering if I could invite you back for another interview session where we talk about the new Article 12 that's titled "Controllable Electronic Records."
You may. I would look
All right,
forward.
we will.
Thank you. Thank you for having me.
Thank you.